the thing is when the market shifts like it gets more complex, doesn't it? You have to like bust out things like escalation clause and all kinds of things that we typically wouldn't do. And yet what I want to warn you is most agents don't know about most of these things. And so also there's strategy in presenting offers and talking through beforehand. So I just want Toni unplugged and you guys get ready to ask questions. As one of our very top broker associates in the office, Howard trusts her, Nikki trusts her, everyone does, because she's so sharp on this. So Toni, what do you feel is the most important thing we share today about this market and getting deals accepted on both the receiving end and the submission end?
Well, honestly, know your contract. That's the biggest thing. And I will say this 1,001 times. We use our contract like a Mad Lib form, and we just fill it in, fill in the blanks, and we just hope for the best, but we don't even know what we're filling in the blanks for and what it means and what the standards of our contract are. And how do we use any of the addenda if we don't even understand what the contract is? So it's really important because you could be putting something, oh, there's my dog. You could be putting something in your contract addenda that is conflicting with what is in the contract itself, or conflicting what's in additional terms, unless you meant to do that.
So what's a really simple example that a lot of people kind of mess up on, but it's pretty common?
Okay, here's one thing. Survey. Does anyone know when a survey's due? Probably not.
Nope.
Yeah, it's due at the same time or before the title contract or the title commitment. So title agents don't even know that. And a lot of them are waiting to the last minute to order that survey. And guess what? Now the buyer is in default of the contract and nobody even knows it. But the good thing is, if you know the contract, great, you're on top of it. You're keeping your title agents on top of it. But the buyer side, if you have the listing, they may not be on top of it. So we don't want anyone to get in default of the contract, and we want to be on top of that stuff. The way I always think in the back of my mind is, if this went to a court of law, was I responsible with the contract? Because that's the foundation for every one of our transactions. So that's kind of one of the big examples, the survey, title commitment. Some people don't know that it's 5 days for cash transactions versus 15 days for financed. I mean, there's so much in this contract and I get so excited about it. I'm like a big contract nerd. So, I mean, did anyone at all know about when the title commitment was due cash versus financed?
Donna does.
Yeah.
Donna does. Go, Donna.
Ding, ding, ding. This is when we need the wheel of prizes.
I know, right?
We're going to get the wheel of prizes for next time. Okay, so let's talk through that, because there's a lot of people like, I don't want to give the wrong answer. So what is the right answer?
And knowing it is, I like knowing it, but I don't really know like how to strategize around it sometimes. Like I read that it's cash 5 days, but I was like, trying to explain the strategy or like benefits of changing that number to my buyer, or, or if it's different for my seller. That's where I fall short.
Yeah. So the contract just says that it shall be given 5 days prior to closing on a cash transaction and 15 days on a finance, because you do have to get that title commitment over to the buyer to review. So whenever I get sent a copy of the title commitment, whether the title company sent it to the buyer or not, I'll put in my email as I send it to the buyer as well, hey, I got a copy of this too. This is what it is. And in a nutshell, this is what it means. You really need to be looking over the title commitment because it lays out everything that's going to be in your title insurance policy with your named insured, the exceptions, and those exceptions are what you really want to take a look at. And if you don't understand it, then let's contact the title company, since they're the licensed title agents, and they can explain this to you. But some of the exceptions might be pretty typical ones, like utility easements. But I've had ones where a builder built part of a pool and the pool deck on a conservation area, and that was uninsurable on the title policy. So the buyer has 5 days upon receipt to review that. And when I say upon receipt, it's not when you give it to them, it's when you receive it as the agent. So there's a lot of things like that that people don't know about, or the escrow deposit. So the escrow deposit is not considered received until it is actually in the title agent's account. That's when it's received. So if you have buyers that are waiting till 5 o'clock on Friday and it's due at Friday at 5 o'clock, well, it's not been deposited into the title agent's account. How do we know who the title agent is? Does anyone know that? No.
Well, the title holding escrow is on the front of the contract, but who's
Yes.
actually closing it? Oh,
Yes, you're right, Donna. Thank you. Yes. Thank
I
you.
think Donna gets a prize. I'll send you something good.
I love Donna today. So a lot of times people think page 1 of the contract is the title agency.
Yep.
But it's the escrow agent. It's the person holding the escrow. Has nothing to do with the title.
Sometimes investors want their own escrow company.
Right, right. And there's a couple of brokerages out there, a couple of firms that use their broker's account still.
yeah, I used to always use my own. I used Star because I trusted them if there was an escrow dispute, that if they had the money, I felt like it was just safer.
Yeah, yeah. So, there's those things. People don't understand that. So what brings me farther into that whole situation is, does anyone know? See, I like that. Did you know in the contract that there was a part in there that actually talks about where the closing must occur?
Yes, in the county that the property is in.
Yep.
Correct.
Yep.
And a lot of people don't know that. So when you have a Pasco listing and the title company is in Pinellas, just because you have the escrow agent on page 1 doesn't mean that we agree that that's where the closing is going to be in Pinellas. So that stuff should be in writing. There's just a lot of things on the contract.
So I had a question about that because I did have a listing where they wanted the title company to be in Pinellas County, but the house was in Pasco County. So I think I just did it via email that you agree that it's okay that it's in Pinellas County, the closing. Is that sufficient?
Yeah.
Okay.
It's in writing, and as long as they, I always have them respond yes or no, so I can confirm that they read and received the email. But
Yeah.
it's just those little things that are on the contract, and so much more. There's just so much more in here. And what's going to really help you guys when you're negotiating contracts and you're negotiating terms and you're going back and negotiating again after repairs or whatever the situation might be, appraisals, you're going to want to know the contract, because you may have boy, I cannot talk this morning. I've not had my coffee, I'll be honest. You may have an agent on the other side. And if you're a newer agent and they've been a seasoned agent and you maybe feel a little intimidated, a lot of times, guys, they're not going to know the contract either. Sometimes they're not even filling it out themselves.
I can tell you that from recently hiring a lot of experienced agents. Our compliance is like, wow, we have some training to do. And it's not, I'm not saying that in a negative way. I'm just saying that's reality. Not everyone has had boot camp. Not everyone has had training like this. And they're kind of just figuring it out as they go. Now, I want to take the rest of the call. I want to definitely take any questions, but let's talk strategy. Because in this market, I think one of the things that's